Hello, I'm Bob Markoff. I'm a collection attorney. My specialty is enforcing judgments and recovering property. I would like to share some information about how to avoid using the sheriff to sell property at a forced sale. The sheriff under Illinois law has been the sole person enabled to sell property. However, with recent changes in our Code of Procedure, the Citation Act, Section 2-1402, the court may authorize a different selling officer if it will maximize value of the property for both the plaintiff and the defendant. About 150 years ago, Abraham Lincoln wrote to a friend, "I do not mind the business of collection process," and I'm paraphrasing here, "but what I hate is chasing the sheriff all over the counties to enforce the judgments." In the 1850s, the only way to enforce a judgment was by having the sheriff go out and do a levy sale, either of personal property or real estate. Over time, our laws have grown. We added garnishment about the 1870s or 80s. We added wage deduction, which is similar to a garnishment. And then we also added citations to discover assets, which are an outgrowth of a creditor's bill, which I'm sure no one watching this has ever seen. Maybe you heard of it in law school. In any event, all property seized other than cash has to be turned over, I should say had to be turned over to the sheriff of the county for the sheriff to conduct a sheriff's sale. Sheriff's sales are terribly inefficient. They achieve maybe 10 cents on the dollar or even less. It certainly does not benefit a creditor. It does not benefit a debtor either. About 8-9 years ago, we had an amendment to the Code of Procedure in the Citation Act, 2-1402 of the Act. You will see a phrase that says, if there is an alternative method of sale that will enhance the value of property for all parties, the court may so order. This means, let's say the debtor comes to court wearing a Rolex watch. Rather than turning it over to the sheriff, the court can order it be turned over to a jeweler and sold on consignment to bring the highest price possible. In addition, if you have a house and you're seizing the defendant's house, and I'm not talking of foreclosure here, the court may appoint a selling officer, a real estate broker, to obtain bids for the house and sell it to maximize its value. Finally, what if you have closely held stock in a corporation or intellectual property that has no obvious value on the open market? How do you sell this property? You may ask the court to authorize a code sale under the Uniform Commercial Code. You advertise the sale in the appropriate papers. It could be a law bulletin, your local newspapers, or even a trade journal. You then hold a sale in your office. You strike off the property to the highest bidder, and then you return to court for sale approval. This is a very effective means to sell such property, and it totally avoids the use of the sheriff and makes life easier for all concerned. If you would like more information, and forms in particular, please visit the ISBA website and look for the seminar on complex asset recovery. There you'll find a segment on the UCC code sales, and you'll find the forms therein. In addition, if I may be of assistance to you, you're welcome to give me a call. My direct line, 312-698-7333. I will be happy to do what I can to help you. Thank you.